Malpractice insurance lawsuits can be expensive. Paying for attorneys, expert witnesses, court fees, and the actual damages for any losses against you can really add up. So, what's included in your policy? Does malpractice insurance cover legal fees? There's one key question that you need to ask in order to ensure that your policy is covering you adequately. Curious to know what it is? Let's go over it together. Stay tuned. Welcome to Malpractice Insights, the show dedicated to helping healthcare professionals understand medical malpractice insurance and providing you with the solutions you need so that you can get back to the work of practicing good medicine. My name is Jennifer Wiggins, CEO of Aegis Malpractice Solutions, and I'm so glad you've joined us today. All right, let's jump in. Malpractice insurance helps healthcare providers pay for attorney fees, expert witness costs, legal fees, settlements, and indemnity payments. There are two types of damages that a patient may seek to recover from you in a medical malpractice lawsuit. Those are compensatory and punitive damages. Let's take a look at compensatory damages first. Compensatory damages can be either economic or non-economic. Economic damages are awarded as compensation for monetary losses and expenses, which the patient has incurred or is reasonably likely to incur in the future because of the healthcare provider's negligence. These include loss of income, medical expenses, and the cost of future medical care. These are the most common types of damages that patients will look to recover in a malpractice claim. Non-economic damages include pain and suffering, scarring, humiliation, permanent loss of an organ or limb, reduced enjoyment of life, etc. Both of these categories of compensatory damages are covered by your malpractice insurance policy. Now let's look at the other type of damage, which are punitive damages. Punitive damages are only awarded if the conduct of the healthcare provider is found to be willful and reckless, meaning you intended to cause harm to the patient. Punitive damages are in excess of those required to compensate the patient for the wrongdoing, and they are imposed in order to punish the defendant. For this reason, punitive damages are not covered by your malpractice policy. But beyond the actual cost of the losses against you, malpractice cases will incur additional expenses, those required to handle the case. The average malpractice lawsuit will incur $25,000 to $50,000 in defense costs. Sometimes that number will be even higher, especially for cases that are very complex or that take many years to resolve. It's not uncommon to see defense costs of $100,000 or more. It's the insurance company's responsibility to pay for your legal fees within the policy limits and the parameters that they have provided. But how does that affect your coverage? Does the cost of legal fees reduce the amount of insurance that you have? There is a key question that every healthcare provider needs to ask before buying a malpractice policy. Here it is. Are defense costs inside or outside of my policy limits? The best malpractice insurance policies will pay for your defense costs outside of policy limits. This means that the attorney bills, expert witness costs, and court fees will be paid for separately and will not erode your policy limit. If you have a $1 million policy limit, that limit is saved exclusively to pay for losses. Defense costs would be covered separately. Other malpractice insurance policies may have defense costs inside of policy limits. This means that attorney bills, expert witness costs, and court fees will be paid for within your policy limits, and it will erode your coverage. If you have a $1 million policy limit, that money will be used to pay for everything. defense costs, and any settlements or indemnity payments. So here's an example. If you have a malpractice insurance policy with a $1 million, $3 million limit, and you're involved in a claim that racks up $100,000 in defense costs, a policy with defense costs outside of limits would still give you the full $1 million in protection for any losses on that claim. A policy with defense costs inside of limits would give you a reduced limit of $900,000. So essentially your $1 million limit minus the $100,000 defense costs. Not ideal, right? If you're buying your malpractice insurance from a large, reputable company, you probably don't have to worry about this. But if you are buying malpractice insurance from an unrated carrier, a risk retention group, or a non-standard market, it is very likely that your policy will have defense costs inside of policy limits. So it's important that you find this out before buying the coverage. Sometimes you'll have the option of choosing between the two, but if you're currently buying malpractice insurance in the non-standard market because you've either been non-renewed or declined for coverage, your policy will likely have defense costs inside of policy limits, and it's not going to be negotiable. If you have any questions on this topic, or you want to make sure that you're covered appropriately, click the link in the description box below where you can connect with us via phone, email, or chat today. And if you're listening, please visit us online at aegismalpractice.com. That's AEGIS malpractice.com. And don't forget to give us a like and please leave us a review. Your feedback and support helps us to reach more people, and we're grateful for your clicks and your kind words. This is Jennifer Wiggins. Thanks for joining us.